Okay. Dearest listener, Chapter 4 of Just Breathe for Caregivers. Introducing our guest, Hellen Ruth. She goes by HR Harwell, and she's an estate planning attorney in Charlotte, North Carolina. So, Hellen,
Yes.
You and I met a few years ago, and it was actually through SCORE that we met, which was a really cool organization for small businesses. You really need to check it out. But you specialize in estate planning, and also the documents that need to be done for someone who is while you're alive, so that someone can take care of you. So would you want to go into that, like why you would need powers of attorneys and living wills?
Sure. Yeah, so as she said, I do a little bit of business law and a little bit of estate planning, or a lot of both. And with the estate planning piece, we do often focus on the things that caregivers need, which include the healthcare power of attorney, financial power of attorney, and living wills, which in North Carolina is also called a declaration of a natural death. And those are the documents that allow your caregivers to take care of you while you are still alive. We also do the wills and trusts and the backside of it for what's going to happen and how things are going to transition after someone passes away. But I think today we want to focus on the powers of attorney and the matters that allow your caregivers to provide the services and to get you the care that you really need.
So why should a family member think about all of this planning before there's a health crisis?
Well, it's very important to get the documents done as soon as you can and as early as you can while you are still alive and competent, to allow your family members or your caregivers to be the people that you want them to be. Because you don't want somebody else deciding who's going to take care of you and make your medical decisions. It needs to be your decision. So doing that early on, in fact, I do documents for people who are turning 18. They need those so that their parents or guardians or whoever's taking care of them has the authority to talk to a medical provider and has the authority to talk to the schools that they're at. There are specific laws that allow an 18-year-old not to tell their parents anything. So if the parents are going to pay for it, they should probably have some say-so. But the 18-year-olds need those documents. You just never know when something's going to happen. It becomes much more difficult and impossible if somebody is physically unable to sign their name or if they're mentally incapacitated. And at the times where there are crises, the last thing you need to be doing or your family needs to be trying to figure out all of a sudden is who can tell the doctors what to do and where are those documents. And if no one is there and available, are you even able to have the capacity to do the documents? The other problem becomes is every once in a while I get a phone call and somebody is actually competent, and they're in a hospital. Well, it costs me more to travel to the client if they're not able to leave the hospital to have them sign the documents. It's also a lot more logistically difficult because making copies and getting witnesses. If you are in a nursing home facility or a hospital, you can't always get, you cannot get the staff, in fact, to witness the healthcare power of attorney or the financial power of attorney because specific requirements in the North Carolina statute prohibit your medical providers from being witnesses on those documents. So therefore, a lot of times I have to either bring witnesses with me. You also don't want it to be the family members or the people named in the documents because then there's all kinds of conflicts of interest. Mm-hmm. So there's very specific statutes as to what you have to follow to make the documents effective, and it just becomes so much more difficult in the middle of a crisis. And that's the point when you need to be focused on the person's health care and taking care of them, not trying to get legal documents in place. Then if you are in a situation where they are not competent, they don't have the legal capacity to sign the documents. Therefore, you're going to have to go through a very expensive process called guardianship. And it's also very time consuming. So no short-term decisions can be made at that point. And you are left to sort of in limbo where you can't necessarily handle their finances. The doctors may not be listening to the right people for the medical decisions, or they may just not do the procedures. I had one situation where a client was taking care of his mom and his grandmother. So his mom was incompetent. She had early onset Alzheimer's. And then the grandmother was marginally incompetent, but she also had cataracts. So grandma had given mom, who's now couldn't act, as her power of attorney, but she hadn't named a backup on the document. And I always push clients to name backups. Without a backup, there was no one there to make the decisions. Now, under the North Carolina law, it does allow your next closest relatives to make some medical decisions, but for non-emergency decisions, he wasn't allowed to get her cataract surgery. So not only is she hard of hearing and having some mild dementia, but she also can't see. Well, and he couldn't solve that problem without going through a very long, drawn-out guardianship procedure.
And the guardianship, just from personal experience, first year out the gate is $25,000 in legal fees. And if you're in Mecklenburg County, because it's different from state to state, to county to county. I've done a lot of research. I've talked to a number of attorneys dealing with it. And if you're in Mecklenburg County, they've had so many problems with guardians embezzling money that they're now requiring the appointed attorney to be the guardian. So as a family member, you won't have any control or say because the attorney's now going to be in control.
Now that's for the money. They do, I believe, my understanding is for medical decisions, they will often name a family member for that. But for controlling the money because of concerns of embezzlement, the clerk of court has decided that most often they are going to probably lean towards naming an attorney. And then that's additional expenses because you've got to pay that attorney their hourly rate to do all of this work that a family member could be doing. There again, if you trust someone to do it. Right. That is also the most important thing is, are the people that you're going to name, are they capable, competent, and trustworthy? Right. With the financial power of attorney, the trustworthy piece is probably the most important, and that they know how to manage their own money, and they're not going to, give it to some scam artist or not use it for your benefit. With financial power of attorneys, the person who is acting as the agent does have an obligation to do an accounting and to show what they're doing with the money and what they're doing on behalf of the person. With the healthcare decisions, and I think I was listening to your podcast the other night as to how much you really had to advocate for the proper care.
Right.
So my standard comment when I'm talking to clients is, who's going to yell at the doctors and nurses to make sure you get the care you need? Who is that person that is going to ask all of the questions and make sure that what you need and what you want to have happen? Like if you want to stay on life support, you want somebody who's going to align with that and who's going to push for that. If you want to be taken off of life support or you only care about pain management, then you want someone who understands and knows what you want and is willing to make sure that you get that care. Because there are different things and different answers for different people, but you want to make sure that the doctors and nurses and everybody focused on your treatment is focusing on what you would want to have happen.
And that becomes such an important part because usually as the caregiver, you are a family member, someone that they trust. And you now have to make decisions for someone, especially under a guardianship, that they never actually wrote down.
Right.
And so you're trying to say, how do I do this? And hopefully they're competent enough, you can have a conversation with them while they're competent before anything happens that they can't make that decision. So this is part of the living will that you were talking about, where they would make decisions for themselves in advance. And as you were talking about doing all these paperwork, the other part of it is notaries. You have to have notaries to sign everything off, along with the
Along
medical.
with 2 witnesses for most of the documents in North Carolina.
Yeah, the medical requires 2 witnesses. It's so important that you have these heart-to-hearts. And I know when we have children, we're not thinking about that, but it doesn't matter how old you are. Once you have a child, you need to put these papers in place. You need to sit down with an attorney and put them into place. You're going to spend a little bit of money, but it will be so much less stress and so much easier.
Peace of mind,
Right.
too.
Peace of mind. Yeah, you've been through that on the other
Yes.
side of it, taking care of your husband.
Right.
Well, and I know we're focused on the healthcare power of attorneys and the things during life, but you did bring up the children issue. And I just want to point out that with the estate situation, if you die without a will in North Carolina and you have minor children, if you have, and you're married, you would assume it all goes to your spouse. It does not. In certain situations, depending on how much the value of the assets are, say you have a bank account with $100,000 or $200,000 in it, or a house that's just in your name, but you would want it to go to your spouse. Well, it's going to be split between your children and your spouse. Or the worst case scenario is you have a business. So now you have a business in your name, and your spouse doesn't have complete control because you have minor children. So now there's a chance that you might have to go through that guardianship procedure for the minor children for their interests in the company that they just inherited. Because if you're married and have children, part of it goes to the children, part of it to the spouse. Also, while we're on that topic, if you're married and don't have any children, you're going to be surprised to know that your parents are going to get a share. And they're now going to have to fight with your spouse. So hopefully they all get along in North Carolina.
Wow, so even the parents, when you're an adult, get a share if you don't have children?
Yes, if you're married.
Wow, that is
Wow, I
definitely.
didn't know that either.
So
Yeah.
if you're married and you care where it goes, you need to specify. You may want some of it to go to your parents. But that should be your decision, not
The courts.
based on the North Carolina statute, which does not really follow. And it really does get really cumbersome when there are minors. I've had a couple of situations where we basically had to wait till the child was 18 to sell and manage a company and handle those kind of things. Fortunately, the children were like close to that age, but it does get messy.
Wow, so that's really
So
good.
it's very important for new parents to do the documents. Not only that, but if something happens to both of you, you want to dictate who's taking care of your children. You don't want the random family member that you does not align with your values showing up and asking for guardianship, because the court's not going to know what you wanted.
So as far as the POAs are concerned,
Mhm.
why does someone who has very little money needs to have a POA? Because, money is an option, for a lot of people, and that's why they don't do this. Because they think it's going to cost out of pocket so much. And I don't know if they really understand that the sooner they do this, the more set they are in their family, and far as peace of mind and so forth. Because God forbid if something were to happen, an accident, which it happens, then you have it in place already. But if they don't, or if they think they don't have the money, what do you suggest?
It is a question of pay now, pay later. And whether if you're prepared for it, you're probably going to pay less to get the documents prepared. If someone doesn't have, let's talk about the financial power of attorney. If you don't have enough money to do a financial power of attorney, then if you become incompetent or you can't go to the bank to handle your finances, you can't sign the documents to transfer money or write checks or do your taxes or handle your other finances or sell your house or sell your car, no one else can do it unless you go through that guardianship procedure. You're going to pay a very small percentage to get the documents done compared to the cost of that guardianship procedure. The guardianship procedure that she was talking about also takes months. I don't personally do those, but I do refer them out to some attorneys that I know. But not only do you have to hire an attorney to represent the person who wants to take care of the stuff, the court will appoint an attorney to represent you as the person who has dementia or needs a guardian.
Mm-hmm.
It is a humiliating process because if you are on the borderline, you're basically having a court proceeding in front of a clerk to decide whether you are competent and whether you can make your own decisions or whether somebody else has to do it. They usually send you to lots of doctors to have cognitive abilities checked. It is a terrible situation to have to go through. So costs much less if you prevent that problem and you do the healthcare and the financial power of attorneys. Also, if somebody can't get to your assets, well, then they may have to wait till you die. And if then you're going through the will to get the assets, you're going to have to go through the probate process, and that is also expensive. Yeah. So if you don't have beneficiaries and you don't work around the probate process, then that's a whole nother difficulty that you are passing along to your family. And there are a lot of situations where a family will come to me after somebody passes away and we're looking at their assets and I'm like, it's not cost effective. I know that you have a car in the driveway and can't do anything with it, but you are going to go through a lot of work to then pay his credit card bills once you sell that car. And there's going to be nothing left for the family members that are doing the work. So it causes a significant amounts of problems that cost more money later if you don't have the documents.
Well, and just kind of a thought that's going through my head when you're doing all of that too. As you mentioned, the financial cost of all of this is, can you give us a rough idea? Because you're right, it was significant. Like I said, the first year was like $25,000 in legal fees because there's so many appointed people for guardianship.
That seems a little bit high from what I understand, but I usually say from 5,000 up.
There's 3 attorneys involved because the incapacitated person gets one. You have to hire one who does a ton of work. Right. And then there's also another one that does all of the review of the financial records and stuff. And they're not worried about the medical. They're going after the financial. Right. And they will actually have subpoena power to pull all of the financial records of the incapacitated person so they can verify all of their assets.
Mm-hmm. That's true. And I wasn't counting in the attorneys or the fees for the person who's actually doing the work once they become appointed to manage the finances.
Yeah, so it just gets really expensive to do all of that. And as I'm just trying to think about this, what are your feelings or thoughts on the bank account? Because putting somebody else on your bank account, if your spouse has passed, changing that, and beneficiaries on bank accounts. I don't think most people realize it's important to go to the bank while you're living and in good health and assign beneficiaries to all of your bank accounts. Mm-hmm.
Yeah, so part of my process when I first meet with a client is we run through, okay, these are the accounts that you have, these are IRAs, these are retirement accounts, these are your life insurance policies, your house, please don't have any timeshares. And what we talk about is what is in those accounts and ultimately where do you want your assets to go after you pass away, and what do you want to have happen while you are alive? Mm-hmm. I have different answers for different clients for different types of assets. So I would recommend that you go and talk with an estate planning attorney, of course, and work through that. That is part of the legal service that you are obtaining by hiring an actual attorney to help you through the process as compared to just doing documents online. Right. You need that legal advice because depending on the situations, and in some places I'll tell you name a trust on this asset, but you probably don't want to name a trust on IRA assets because those have some tax complications. Mm-hmm. But every once in a while there'll be an exception to that, which is why all of this is very tailored to my specific clients as to what you do. Some of the options with your regular checking bank account are to name beneficiaries. Mm-hmm. A lot of times the banks won't let you name a contingent beneficiary, at least they wouldn't with my account. Mm-hmm. So in that situation, the person that I would have had contingent, I just made her joint so that the two people will receive the money after I pass away. The other option, I name them beneficiaries. The other option is to have somebody joint on your account. Mm-hmm. So when you do joint, you want to make sure that it's either joint with right of survivorship if you want them to inherit after you pass away.
Hold on right there. That's a very magical term that everybody needs to really understand. What with right of survivorship
it is key for many of the beneficiary type designations or joint ownership situations.
And so explain that a little bit more as to what that means.
Okay, so I'm going to back up. So you can own assets in many different ways. One is you are the sole owner. So if you're the sole owner, then you're the only one who has access to it. And if you pass away, it's going to go through the probate process through your will. Another is to own it joint without right of survivorship. So that means that you and the other person each own basically, it's presumed 50%. There are some ways that you can prove later that it's not, which means that half of it goes through probate. The other is with right of survivorship, which means that it's joint and commingled money today, and that person can write checks to your medical providers, they can handle their things, they can also go give the money away to their friend, or pull it out and put it in a different account for themselves. So it is your money and their money together. The with survivorship means that if one of you passes away, it's automatically the other owner's asset. So they don't have to go through as much. We do often have to get records for the court if we're going through probate for other things to show the court what money is there, because if there's not enough money for creditors, sometimes the court can grab it back to pay the creditors of the person who's deceased. This also applies not just to your bank accounts, but it's very helpful to have a joint with right of survivorship account. You can also have an account that's a sole name, but you have an authorized user or signer on the account where they have to use it sort of as using it as if they are your power of attorney. And a lot of times they are your power of attorney. Typically those accounts do not name beneficiaries, which means that they would go through your will and through the expensive probate process. So when you're putting somebody on your account, there's different ways to do it. You need to be very strategic about what the goal is and what power you're giving them and how much convenience you want it. The other thing is a lot of people will put one child on their checking account, but the other child's not in town, it's not convenient, so they're not part of it. Well, that means that whatever's in that account is going to go to that one child. It's not going to be equal or necessarily follow your will or however you want it to, because the beneficiary designations and the ownership classifications are supersede anything that might be in a will or a trust or other document, because you've agreed with the bank that they can just, with a death certificate, pay that person. And you may not want to rush and change things when somebody passes away. You want to go talk to somebody and do that in a little bit more of a strategic manner as well, because it can cause some problems when you close out an account, especially if there's automatic things come in and out of the accounts.
I have a question. Just to clarify. POAs is for someone who is alive.
Yes, they end the moment someone dies. North Carolina says so that you can no longer use the power of attorney.
Right. So I wanted to make sure they understand that, because that's what happened to me, right? I had a POA on my husband. As soon as he passed away, that POA was no longer in service.
Right.
And then we had a will, and then we had right of survivorship too. So I was able to get the money that we had and the home that we had into my name because of the right of survivorship.
Yeah.
So that's why it's so important that you do that. And once they pass, what can they do in order for them to take ownership? Just the joint account or right survivorship, is that it? Or is there other means that they can do?
If it is a joint with right of survivorship account, then they already own it. So there's no action that really needs to be taken immediately, because it is their money. They can continue to write checks out of it. If it is a power of attorney account or a sole owner account, and they were using the power of attorney, they have to stop writing checks. They also have to stop using your credit cards, by the way. I had some people where the spouse was an authorized user on somebody's credit card, and their spouse passed away, so therefore the credit card basically ended. And if you're spending on someone's credit card the day after they died, well, you're not an authorized user anymore, because they don't have the power to give you that authorization. So go get your own, make sure each spouse has their own credit cards, please. But it does create some problems when the power of attorney ends. Then you need to go through the process of figuring out, and each type of asset has different rules, different requirements. Every bank has different ones. You can have one account at one bank that says one thing, and one account and another account at the same bank that says something different. The same is true with real estate. Probably we want to talk to an attorney there, because in North Carolina there's a thing called tenancy by entireties, but it's not like the deed says tenancy by entireties. It's sort of fine print as to how that is accomplished, saying, and wife and spouse or and husband to form that joint with right of survivorship type and some other protections.
Well, and this is really important, I think, for a lot of people to understand. HR is in North Carolina. She's in Charlotte.
Yes.
So she's really dealing with not just North Carolina, she's dealing with Mecklenburg County rules and regulations.
I do some in Union County, Rowan, and some of the surrounding counties, but 90% of it is Mecklenburg, yes.
When we're talking about this, generally a lot of it applies across the board no matter where you're at, but it changes and there's variations between states, and states have their own rules and their own regulations. So it's very important to be able to understand and sit down and talk with an attorney, as we keep talking about. This is so important. And put your affairs together in a proper order, because, as you said, if you don't, experience with guardianship was eye-opening, to say the least. And when the person you love has gotten sick, they're in the hospital, and all of a sudden you're having to jump in and do this, and you're right, it takes 3 to 4 months to get a guardianship put into place. It is overwhelming, and that's just the start of the caregiving journey.
And it distracts from you actually taking care of the person.
Yeah, it's
and
very
it
difficult.
it makes things so much difficult at literally the most difficult time in your life, or that person's life. As a caregiving is the hardest job, and both of you have been through it and done it, and it is literally the hardest job of any job in the world, because it doesn't end. I mean, you're asleep and you hear a noise, and sometimes you don't even get to sleep because you need to be there to make sure that the person is getting the care that they need.
And whether they're at home or if they're in a skilled nursing or assisted living, because even if they're in a facility, you can get a call at 2 o'clock in the morning because something's happened. They've fallen, and you've got to go run and make sure they get checked out at an emergency room. You never really let your guard down. You never really. So just think of caregiving if you've had a child, a little tot, where you could go pick them up, take care of them. They were easy to maneuver. You're taking care of a baby. So your responsibilities are not just the care of that baby. This is now an adult you're taking care of. Now you're taking on their financial responsibilities and all of the assets that they have. And it's overwhelming at times.
I was actually talking to a client on the phone this week, and we were trying to go through and just make sure that she didn't need any changes to documents and things. And her husband was in the other room, so we had to postpone the appointment for a little bit while the hospice nurse was there taking care of him, and so that she could deal with that. And then she was like, okay, well, I might have to go if he needs me or does anything. I could just picture her. She was sitting in like a room, looking through the door at his bed, just making sure he wasn't going to get up out of bed or do anything or need anything. So she was literally vigilant. Not just on call, but vigilant, waiting. So just trying to make phone calls when you're in the hospital or in a hospice situation, or you're waiting for a doctor's call, it just becomes so much more critical and crisis oriented that trying to come back to the legal pieces is just overwhelming, and it just adds so much to the plate of the person who's already 100% consumed trying to make sure that you're okay. So the nicest thing that you can do for those people is to have documents and things in place, and to have your information so that they know how to do things on your behalf available. We haven't even gotten to passwords and how to get into things.
Oh my gosh, yes. That's something that we're working
Probably
on.
that's another podcast.
That's a whole nother podcast that's already crossed our minds and that we are considering and working on. But I just kind of really wanted to make sure that everybody knows how to contact you, because we've talked about a lot. And if you're in the Charlotte, Union County, Mecklenburg County, then HR is really a great resource, a great person for you to contact, and to be able to help get this process. Please don't wait. All I can tell you is please don't wait, because you never know when something could strike. I mean, COVID was a massive experience for many of us, and now there's some weird virus that's actually killing people that is out there, and these things happen all the time. We don't have control.
Right.
Car accidents happen. I've known of people falling off of roofs and dying.
Right.
Yeah.
It's really important that you don't wait. So tell us how they can reach you in case they need help.
So the car accident thing is very real. I just after law school, my fiance died in a car accident. So you can get a phone call at any time, any of the day. You just never know when it's going to happen, and that is part of the reason that I do this, is trying to help people through the grief process, because it is very difficult. My office is at the Carmel and 51 area, and in Charlotte, North Carolina. It's Harwell Law Firm, HARWELL Law Firm.com is the website, and we do offer legal services in the estate planning, estate administration, trust administration, and small business law. Help people buy and sell businesses, or also help with the transition of a business during the estate process.
I want to thank you. It's been a pleasure having you here.
Yes.
And
Great.
just so that we can thank our listeners for coming to check us to tune in and listen to us and share this with your friends and family, because sometimes people need to hear it from someone that's not family. Upcoming guests, we do have another attorney coming in, but they are the South Carolina attorney.
Because it is just a little bit different, especially related to real estate and some other matters. You do want state-specific documents.
Yes. And I've had that experience
So-
firsthand.
Please send us your questions at together@justbreathe4caregivers.com. So again, the email is together@justbreathe4caregivers.com. And have a great day.
Thank you.
Thanks.